Hey everybody, it's Paul from Cary Estate Planning, and today we're going to do a question and answer session about estate planning topics, about probate, about trusts, about wills, and a lot of different things. And so I'm going to go through several different questions and answer them directly. And so we're going to start with the first question, which is, can an executor throw away the personal belongings of the deceased without telling the beneficiaries? And the direct answer is it depends, right? So it depends on what the best interests of the beneficiaries are. So generally speaking, the best outcome would be for an executor to basically put beneficiaries on notice of their right to receive personal property from the deceased, give them an opportunity to make claims known as to what they would prefer to receive. In most instances, the executor is going to have discretion as to who gets the personal belongings of the deceased within the class of beneficiaries of the will, who is to receive the tangible personal property of the deceased. So if there's, couches, for instance, they could allocate couches to a specific beneficiary and not others if there's a reason to do that. A lot of times there's sort of this intermingling of practical and legal when it comes to the administration of personal property that, the executor will generally consult with or often at least will consult with beneficiaries to see what they even want. And they'll dispose of or discard a lot of the personal property of the deceased because it has no value. Or there may be, reasons otherwise, like it's stained or maybe hazardous, to transfer to somebody otherwise. And so that's why we sort of come back to maybe, or it depends, is, some personal property or belongings of the deceased will need to be discarded, donated, or, trashed. But, things that have value, whether it's sentimental or monetary, will generally have to be disclosed to the beneficiaries. And then ultimately, at the end of the administration, the executor has to submit a accounting basically showing what they've done. And so when it comes to the question of, can an executor just unilaterally throw a bunch of stuff away without telling the beneficiaries? Generally it depends, but overall, no. I mean, they shouldn't be doing that. They have a duty to always do what's in the best interest of the beneficiaries of the estate, and then also what's in accordance with the will's provisions. The second question is going to be a little bit longer. It says, my grandpa, who raised me, named me as his sole heir. I was his caregiver in his old age. My uncles, outraged, emptied the house of everything of value and totally wrecked the place. What can I do? So if you're going to be the sole heir and executor of the estate, you can bring legal proceedings to recover personal property that has been converted or stolen from the control of the administrator or the personal representative, whoever's serving. In this sense, it looks like it was named in a will, so it would be the executor. Usually you sort of start that with, a demand letter, some sort of legal correspondence that is seeking the return of the property itself. If that's not responded to well, then you can escalate to getting the sheriff or the courts involved to recover that property. Is it possible for an attorney to steal money from an estate in probate? Literally, no. Now, you can run into issues where, lawyers who are not operating within their fiduciary responsibilities may do essentially what's akin to stealing, which would be, overbilling or, taking a commission that's not their fair share, that sort of thing. It may seem like stealing, but it's not literally stealing. But generally speaking, no one can, steal money from an estate in probate. In North Carolina, everything is sort of checked and overseen by the clerk of court and the many employees within that department, deputies and assistants. They're basically overseeing the administration to make sure that it's consistent with state law and consistent with the rules in place, whether that's the rules of intestacy in the absence of a will, or the rules of the will itself if there is a will. And so that pretty much precludes anybody from, quote unquote, stealing from an estate through the probate process. But it doesn't mean that people can't favor themselves. Generally, it's pretty hard for a lawyer, unless they're actually serving as the personal representative of the estate, to pay themselves or to do anything sort of unilaterally against an estate, because they're usually in a support role. Usually lawyers represent executors or administrators in the administration of the estate. They're not actually the ones cutting checks or getting access to funds. That's always going to be, there's always a potential for a lawyer to serve as the personal representative though. But generally speaking, no, lawyers can't serve or can't steal money from an estate. Next question is, can you empty a house before probate? Generally, the answer is no. Now, it depends on what you're speaking to as far as empty is concerned. Now, can you clean out a house, to dispose of trash and things that need to be discarded, or things that will otherwise be donated because they have no value? Yeah, probably. If you are the person who is, ultimately going to be the representative or beneficiary of the estate, yes, I think that that's practical, especially if it may damage or reduce the value of the house otherwise. But as far as, personal property, things that have sentimental or monetary value, the answer is no. It has to be administered according to the rules in place, whether that's the rules of the will or the rules of intestacy in the absence of a will. Next question is, who should I name as an executor of my will? Generally speaking, if you're married, a lot of times people will name their spouse as their primary executor, and then other people that they trust as alternates. If you're not married, then you're just going to basically audit your important people in your life to see who would be a good fit for the role and what it entails. Generally, it can be very limited if you have a lot of non-probate assets, or it can be pretty involved if you pass away with a lot of debts or had a lot of assets that were not transferable on death. It really depends on your circumstances, but you generally would want to look for people who live in the state. If you have responsible and trustworthy people in your life, whether they're family members or friends or colleagues or neighbors, they don't necessarily have to be in the state, but it makes things easier. If they're out of the state of North Carolina, then they would have to appoint a resident process agent to be able to receive legal process on behalf of the out-of-state executor. But generally, you're going to want somebody who is an adult, who is otherwise qualified to serve. So they're not a felon. They are 18 or older. And somebody who is at least a little bit savvy as to how money is administered, keeping track of statements, invoices, receipts, creditor claims, pleadings, filings, that kind of thing. Otherwise, you're sort of picking your best options, right? Nobody's perfect, but you're trying to give authority and empower people who are going to do the best job for you. So you don't necessarily have to let perfect get in the way of good, but you certainly should not appoint people who are not going to be right for that role. Next question is, what is the worst part of going through probate when settling an estate? Generally, I think the worst part is when things aren't under control, right? So probate does not have to be that difficult in North Carolina. It gets difficult or becomes difficult when you sort of lose control of the finances, the pleadings, the creditor claims, when things get sort of off the rails, so to speak. That makes things pretty difficult. Certainly litigation can make a probate circumstance a lot worse than what it otherwise would be. And then when an estate is insolvent or otherwise is lacking assets and there are significant creditor claims to be made, And then, of course, when beneficiaries don't get along, or when beneficiaries are difficult generally, it can make things more stressful because they may not be okay with waiting for the process to take place. They may be, putting pressure on people to get their fair share quicker and those sort of things. So that's generally, the downsides or the worst parts about probate. And those are not necessarily going to happen with every estate. They're just things that could potentially happen. Next question is, can the sole executor cut you out of the family will? Generally, no, because the will controls. Nobody can modify a will after the testator has passed away. The only person who can modify the will is going to be the testator themselves. It's the person who put it in place. The will has to be administered according to its terms, and the executor does not have the executor or the discretion to remove beneficiaries. They certainly, if there's testamentary trust provisions, may have a little bit more discretion in how a beneficiary receives their benefit, but not whether they get it, right? They don't have the ability to unilaterally, cut someone out of a will, so to speak. Next question is, can I give part of my inheritance to someone else? It depends on when you mean, right? So before you get it, not usually. Most wills and trusts have what's called a spendthrift provision, which prohibits beneficiaries from assigning their interest under an estate or under a trust. But once you receive the inheritance, so if you're a beneficiary under will or under trust and you actually receive the distribution, then you're free to give it to whoever you want, because then it's just your property. But before it's received, usually the only right you have is to not receive it, right? It's not to assign it to someone else. You can basically disclaim or renounce your role in receiving an interest in an estate, but you generally can't assign it. Next question is, do bank accounts go through probate? Generally, they can, and a lot of times they will if people do not beneficiary designate them. So if they are owned in the name of a person who deceases or becomes deceased on their date of death, and the account is not otherwise subject to some form of right of transfer, like rights of survivorship or a transfer or payable on death designation on the account, then the account will go through probate. And the concept there is that the probate process is needed to transfer legal title to that account. And so since it has the deceased's name on it, the clerk of court in North Carolina, the court process of probate, is the sole remedy of removing that name from the account and assigning it to someone else according to the rules of the estate, or cashing out the value and paying it to someone else, depending on the type of transfer. Next question is, what is the biggest problem caused by an inheritance or a will that you ever saw or heard about? From personal experience, us assisting in the administration of an estate, the biggest problem that we ran into was probably out of country assets. And this was essentially someone who passed away here, who worked for a company that had an international presence, was headquartered in another country, and the stock account that he received as a benefit of working for that employer actually vested the stock into a foreign bank account. And so that piece alone probably added 1.5 to 2 years onto the probate process, because it just took so long to coordinate with the consulate and submit pleadings through the consulate to the foreign bank account, just to get things moving. That's probably the biggest issue that we've had. A close second would be litigation, right? So when a deceased is sued, their estate is sued, the estate has to stay open in order for the executor to defend the lawsuit or to actually participate on behalf of the estate. in the lawsuit. So those would be probably the two biggest issues that we've ran into, and those were just in the last few years. How do I confirm there was not a will and testament for my parents' estate? So generally, the law is going to require you to search through what would be considered their, important papers or areas within their home or their office if they had one, where they would keep important papers. So this could be a safe, could be a lockbox, could be a drawer, could be a desk in the home. Wherever they would normally keep important papers, that's where the law presumes they would have kept a will if they had one. And if through diligent effort you find no will, and you call around to local estate planning lawyers and there's none to be found, the law will presume that they either didn't have a will or they had one and intended to revoke it. So that's generally, some diligence that needs to be done first. You can't just say, well, I don't know where it is, so it doesn't exist. You have to actually look around and see if you can find a will. Next question is, why would a will not go to probate? Not every will has to be probated. Now, wills, the process of administering a will is through the probate process, but wills only have to be probated to the extent that they control the transition of an asset. So for instance, if say an elderly individual does not own real property, maybe they're renting or they live in an assisted living facility or independent living facility, and they don't own a motor vehicle, and they otherwise beneficiary designate all of their financial assets, it's unlikely that the probate process would be needed to transfer property at all, right? So all of those financial assets would transfer themselves as long as the beneficiary survives the deceased. And then the will, which would otherwise be needed to pass title to real property or personal property, wouldn't be needed because they didn't exist, right? This person didn't own a home, didn't own a car. Those are, the primary reasons why you would need to probate a will. So if we were able to access and resolve and settle all of their assets without the need for probate, then a will would not need to be probated. Sometimes you just, as a matter of course, file the will though. Next question is, does a life insurance policy have to go through probate? Most of the time, the answer is no, and that presumes that the life insurance policy was beneficiary designated. Now, I say most of the time because we still administer estates where the life insurance is the sole asset. I'm doing one right now, for instance, where it was over $100,000, $150,000 policy that had no designation on it. So generally, in the absence of a beneficiary designation on the life insurance policy, it usually will pay to the estate of the deceased. And if that's the case, then you now have, the cash death proceeds, not the policy itself, but it's the death proceeds of the policy that have to be administered. And it's essentially a check that's made out to the estate. There's no way to receive the benefit of it without administering the estate fully. Next question is, can you decline an inheritance? Yes, you can. You can disclaim, which is basically, you file paperwork with the estate, usually giving it to the executor, saying that you don't want any benefit from the estate itself. You can also disclaim specific assets. If they are beneficiary designated, you could disclaim a 401k, for instance, life insurance benefit, that kind of thing. And it basically treats it as if you've predeceased the deceased, right? So it takes you out of the line of inheritance. Sometimes that's a good move. Sometimes it's not. Depends on who the next beneficiary in line would be. Next question is, what role does an executor of a will play? The executor is someone, it's a person or sometimes multiple people who are named by the will's creator, which is also called the testator, to administer the will after they're gone, right? So this is essentially transferring legal title to probate assets and then receiving any claims by creditors on behalf of the estate, and then basically resolving both of those issues. making sure that creditors are paid if their claims are valid, and then making sure that assets are distributed or paid to beneficiaries after claims are satisfied. That's essentially the executor's role. They're administering the estate according to the rules of the will. Next question is, does the executor of a will decide who gets what? Yes and no, right? So no, in that the will itself names the beneficiaries of the estate. So for instance, if you had 2 kids and your 2 kids survived you and you name them as beneficiaries, like to my then living children in equal shares, then the will sets out who gets the estate and their respective shares, right? 50-50 between 2 kids. The executor, though, decides or can decide within their discretion what makes up those 2 50% interests. So that could be allocation of real property, could be allocation of personal property. It could be a clean break or clean division of all assets, or some combination of the two. So they get some discretion as to what makes up the shares for the named beneficiaries, but they don't decide who the beneficiaries are or what their respective share is. Next question is it unfair to exclude adult stepchildren from my will? If my husband and I were to go at the same time, I would like my half of our assets to go to our adult biological children only. If he goes first, the assets will come to me. Yes, it's totally fair if you believe it's fair, right? And this is obviously a discussion that spouses should have with each other. And of course, it's subject to state law to the contrary, right? We have spousal elective share rights in North Carolina that precludes the disinheritance of the surviving spouse. But it's often the case that blended families where one or both spouses have children from a previous relationship, they will treat their own kids differently, right? They may favor their own kids to the detriment of the other spouse's kids. And that's just sort of the realities of life. Now, we need to be transparent about that and plan accordingly so that everybody's on the same page. But we often will see people, designating specific assets to go to their kids directly at their own death, or some sort of division after both spouses have passed, maybe in a trust that becomes irrevocable at the first death, to make sure that it happens, right? It really depends on the objectives for either spouse, if there's a survivor, and then the kids overall. But fair, yeah, absolutely, as long as you're on the same page. Now, I would not recommend, crafting this strategy without being, transparent with the other spouse. That might not be fair, but certainly, having the discussion, I think most spouses in this circumstance would want that as well, right? They want to make sure that their own children are not cut out of the loop. Next question is, if a family member dies, how do you find all of their assets if they didn't leave a will or any details on beneficiaries? That's a hard one, right? So you first would start watching the mail, see if any paper statements are issued in the mail for things like investment or bank accounts, life insurance, retirements. They often will generate monthly or quarterly statements setting out, where an account is located, the value of the account, how it's owned. Sometimes if there's a beneficiary or co-owner listed, you generally would also, contact any financial establishments that you knew at some point your family member utilized, whether it's an investment location or a bank, something like that. There's also a clearinghouse for life insurance policies. It's not for every single carrier that issues life insurance, but there are some major carriers who participate. So if you're a beneficiary, if you believe that you're a beneficiary, you can search your own name and see if you've been named as a beneficiary under a policy. You can Google that. Those are good places to start. You also would look through important papers if they, had a safe or lockbox, you tried to access that to find any statements or bank records or anything like that. And then you're trying to basically, connect the dots and follow the breadcrumbs. Next question is, how and when can a will be challenged? So in North Carolina, you actually have a few options. We currently have a process that's called living probate, which is essentially the process of validating and proving a will while its testator is still alive. So you could file for that as the testator, you could file for that as the beneficiary, but it's basically trying to challenge the veracity of a will while its creator is still alive. The most common opportunity or timeline when a will would be challenged, though, is after it's been submitted to probate. And that's what we call a caveat proceeding. So that's essentially somebody submitting a will that you may either disagree with its validity, you may disagree that it is the current or binding will, or you may disagree that it was created appropriately, right? That the testator had capacity or was not under duress, those sort of things. That's generally when you would challenge it. But the how is either via living probate or via caveat during the probate proceeding. You wouldn't want to wait until everything's been done, right? You don't want to wait until the estate has already been settled. You want to basically challenge the settling of the estate, basically saying that the will itself is not valid or some portion of it, right? Does an executor's job end when the probate court is closed? I would say no. I guess I would probably need to know more about how the court is closing, but generally the executor's job is not done until they are discharged of their fiduciary duty, right? And that would be at the end or the resolution of the estate itself. A court closing, for instance, if a county court permanently closed, they would likely just assign all of the active files to another court. So that wouldn't really impact anything. What's the easiest way to put together a will without spending any money? Great question. All right. So you certainly could find probably free will templates online. You sort of rely on those to your detriment. The second option for, a free testamentary instrument would be what's called a holographic will, which is a handwritten will, one that's in your handwriting, signed and dated, that effectively disposes of your estate, appoints an executor, names beneficiaries of tangible personal property, real property, residue, all those sort of things, waives bond. If you can sort of check all of those boxes that you would normally see in a will, you can certainly handwrite a will. And we see those not super common, but they still exist. And North Carolina does recognize them. They are valid. Next question is, do I need a will if I want to leave everything to my spouse? Generally, yes. Not necessarily because it's required to leave everything to the spouse, but just because it precludes any sort of alternative for assets that are not going to be either rights of survivorship to the surviving spouse or transferable on death to them. So for instance, it could be inherited assets that you want to go to the spouse, could be things that you didn't even know that you had. Could be any sort of interest that's not subject to beneficiary designations. Having a will basically just, closes the loop and makes sure that anything that falls through the cracks does make its way to your spouse. It also allows you to appoint them as your executor and to be intentional as to who is your alternate executors, but also to preclude an outcome where somebody that you don't intend does get money or assets from your estate. So it allows you to name, alternate beneficiaries if you and your spouse both pass away together. It looks like that's it for today.